Hello, I'm Eric Rudolph. I'm an estate planning attorney who specializes in helping clients like you avoid probate. What is probate? Why do you want to avoid probate? How do you avoid probate? I'm going to answer these questions and more. So what is probate? Probate requires court supervision and a judge to validate the will, ratify the appointment of the executor, and oversee the distribution of your assets. Probate is the process in which your assets are gathered, your debts, taxes, and expenses are paid, distributions are made to your beneficiaries, but all of this requires court supervision. Why do you want to avoid probate? Probate is expensive. The main reason people want to avoid probate is the high costs and fees associated with the probate of an estate. There are court costs that must be paid. Accountants, attorneys, appraisers, liquidators, and realtors may be involved, and all of them need to be paid from the estate. Attorney's fees are the most expensive. Attorney fees are set by the probate code and cannot be negotiated. Attorney's fees can eat up tens of thousands of your hard-earned dollars. Probate proceedings can take up to 2 years. Probate is subject to the court calendar and court control of your assets. A judge must oversee and approve all actions taken by the executor. Distributions to beneficiaries do not happen until the end of the probate proceeding, and it can be years before your beneficiaries see any money or property from your estate. Probate is a public proceeding that does not protect your family's privacy. Your will and other probate documents become a matter of public record. Nothing is kept confidential, including your assets and who you're leaving them to. Anyone can go to the courthouse and access your probate file, including your will. How do you avoid probate? Joint tenancy, pay on death accounts, transfer on death beneficiary designation, life insurance benefits, gifting during your lifetime, and revocable living trusts. Joint tenancy comes with right of survivorship. When one joint tenant dies, the other joint tenant takes 100% ownership of the property. No probate will be needed to transfer property held in joint tenancy. Pay on death bank accounts offer one of the easiest ways to avoid probate. Checking accounts, savings accounts, and certificates of deposit can all be set up as POD accounts. Fill out a simple bank form naming the person you want to inherit the money in the POD account at your death. After you pass away, that person goes to the bank and shows the death certificate and their ID, and the bank releases the money to them. Transfer on death designation is usually done with brokerage accounts and qualified retirement plans like IRAs, 401ks, 403bs, and other retirement accounts. Transfer on death or TOD accounts will pass to the person named to receive the money in the account upon the death of the account owner or the second account owner in the case of spouses, without the need for probate. So long as the named beneficiary survives the account owner, this arrangement will eliminate the need for the account to go through probate. For IRAs and qualified plans, you should always name your spouse as the primary beneficiary for tax purposes. Life insurance uses beneficiary designations to transfer money from the policyholder to a beneficiary when the person insured under the policy dies. By naming a beneficiary on the life insurance policy, the beneficiary receives the money directly from the insurance company, and there is no need for probate. Gifting. If you give your assets away during your lifetime, then probate can be avoided for those assets. If you give something away, you no longer own it and is not part of your estate when you die and cannot be subject to probate under your will. With a revocable living trust, your assets are placed into your trust during your lifetime and are transferred to your beneficiaries upon your death. Assets held in your trust will not need to go through probate. Legal fees and costs for probating an estate are much higher than the fees for administering a trust. Probate can take up to 2 years to complete, but a trust administration is much shorter. It usually takes about 6 to 9 months for the average administration of a trust. It protects your family's privacy. No need for a probate hearing or for a judge to validate your trust. There's no public record at the courthouse that anyone can access. Usually only an attorney or an accountant and your trustee will ever see your trust. Reasons to avoid probate: court costs and court control of your assets, high legal fees, length of time to make distributions, court delays, and lack of privacy. For more information on avoiding probate and planning your estate, please visit my website at www.rudolphlegal.com. Thank you for watching my video.